This is Bloomberg Law with June Grasso from Bloomberg Radio.
The writ of habeas corpus is a bedrock American legal right embedded in the Constitution. Yet White House Deputy Chief of Staff Stephen Miller said the administration has been actively looking at suspending habeas corpus unilaterally.
Well, the Constitution is clear, and that, of course, is the supreme law of the land, that the privilege of the writ of habeas corpus can be suspended in a time of invasion. So I would say that's an option we're actively looking at. Look, a lot of it depends on whether the courts do the right thing or not.
Habeas corpus has been suspended only 4 times in our history, basically for reasons of war and insurrection. My guest is an expert in constitutional law, Jonathan Adler, a professor at Case Western Reserve Law School. Tell us about the history of the writ of habeas corpus.
So the writ of habeas corpus traces its way back to the Magna Carta. Literally, habeas corpus is a declaration that you have the body. The idea is that you're challenging the alleged unlawful detention of someone by the government. The writ of habeas corpus has been recognized going back to the 17th century as a way of challenging, in England at least, the king's right to incarcerate people. And in the United States, the writ of habeas corpus is a way to challenge either a conviction or the government's detention of an individual on the grounds that it is not consistent with law. So in the case of a conviction, we see writs of habeas corpus filed by people who have been convicted of crimes, often people who have been sentenced to capital punishment, challenging the regularity or the lawfulness of the proceedings through which they were convicted. And then the writ of habeas corpus can be filed in cases where, for example, someone is alleging that the basis upon which they have been detained or arrested is unlawful. So we've seen this with alleged enemy combatants, and we're seeing it now with individuals who are alleged to be unlawfully present in the country or potentially subject to deportation.
The section of the U.S. Constitution that includes the suspension of habeas corpus grants its powers to Congress and not the president?
Well, that is the way we've generally interpreted what we call the suspension clause. So Article 1, Section 9, which is a portion of the Constitution that identifies limits on Congress's power, has a clause that we refer to as the suspension clause, and it reads, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it." And given that it is in Article 1, Section 9, it has always been interpreted as placing a limitation on Congress's ability to suspend the writ of habeas corpus. And that interpretation goes back all the way to, I believe, 1807 is the first time the Supreme Court, in an opinion by Chief Justice Marshall, indicated the understanding this is Congress's authority to decide that habeas corpus can be suspended. And historically, with one exception, when the writ of habeas corpus has been suspended, it has either been suspended by Congress or Congress has delegated to the president the authority to suspend the writ in specified circumstances.
That interpretation of the habeas corpus clause has been affirmed in Supreme Court opinions in modern times?
Yes. So, for example, in the case of Hamdi, which was a case involving an individual, an American citizen, who was allegedly captured in Afghanistan as a fighter with the Taliban. He was brought to the United States, and he filed a petition for a writ of habeas corpus. The question was whether or not he could be detained in the United States without being subject to trial. And if one goes through the opinions in that case, while the justices disagreed on a lot of questions about what sort of process Mr. Hamdi was entitled to and what other constitutional protections he deserved, all of the opinions operated on the premise that if the writ of habeas corpus was to be suspended, it had to be done so pursuant to an act of Congress. Subsequent to that, in a case called Boumediene, also involving alleged enemy combatants, the majority opinion of the Supreme Court in that case made clear that this is a check on executive power, that the writ of habeas corpus often in this sort of context serves as a check on executive power, and it obviously could not serve that function if the executive branch could unilaterally just decide to suspend it.
So if the Trump administration actually did decide to suspend habeas corpus unilaterally, would that definitely constitute a constitutional crisis?
Well, two things. First, I think when one looks at Miller's comments, I think he was perhaps being very careful. He said they were looking at the option of the privilege of the writ of habeas corpus being suspended. He did not say whether the executive branch was going to try and do that unilaterally or whether they were going to ask Congress to do it. My own view is they can look at it all they want, because if they do look at it, they'll realize that they do not have the authority to do it unilaterally. The one time the executive branch did suspend the writ of habeas corpus unilaterally was during the Civil War, when President Lincoln suspended the writ in Baltimore out of a concern that rail lines to the nation's capital would be severed or blocked, and that would lead to the fall of Washington, D.C. to Confederate forces. And even that, in such an extreme circumstance, when the nation was in civil war, when there were hostile troops threatening the nation's capital, even that was recognized as an extreme action. It's one that Congress later ratified, but most people accept was not consistent with the Constitution structure. So if the administration were to try to suspend the writ of habeas corpus, I'm not particularly doubtful that courts would conclude that that was unlawful, that the administration lacks that authority. And I think they would primarily do so on the grounds that it's just not something the executive branch can do within U.S. territory during peacetime, et cetera, that there's no question that the executive branch does not have that sort of unilateral authority. The more interesting thought experiment would be, what if the administration could convince Congress to suspend the writ? And as I noted before, the language of the suspension clause refers to the reasons why the writ could be suspended. It says that it shall not be suspended unless when in cases of rebellion or invasion. And so hypothetically, if the administration were to convince Congress that illegal immigration is such that it constitutes an invasion and Congress were to suspend the writ, there is an interesting question about whether or not that judgment by Congress would be subject to judicial review. I think the prevailing wisdom is that whether or not Article 1, Section 9's requirements have been met would be a non-justiciable political question. But that's really just a thought experiment, because that would require Congress passing legislation to suspend the writ. And, it's pretty clear with the margins in Congress right now, that's not something that is even remotely likely.
The grounds that they refer to for suspending the writ are the same grounds basically that they referred to for invoking the Alien Enemies Act. And at least 4 federal judges have found that America isn't facing an invasion by undocumented migrants, but the Supreme Court did allow the Trump administration to continue invoking that Alien Enemies Act as long as they gave due process to the immigrants.
Right. So the Trump administration is being required to allow individuals detained to file petitions for writs of habeas corpus, and I expect that would continue. I mean, in the background here, there is this longstanding notion that certain questions relating to national security, perhaps even some relating to the border, are what we refer to as political questions, questions that are resolved by the political branches, not by courts. And insofar as these questions touch on that, the role that courts have played is to make sure that the legislature and the executive branch each perform their respective functions, but to not second-guess their determinations. So if Congress were to conclude that waves of illegal immigration are at least potentially an invasion for purposes of the suspension clause, I suspect courts would allow that to stand, not because they would be saying Congress is correct, but because they would be saying the courts don't get to second-guess that. Now, having said all that, I don't think there is any question as a historical matter that illegal immigration, even at far higher rates than we see now, would not constitute an invasion for purposes of that clause. The language of the suspension clause is invoking the idea that there are certain situations, such as rebellion or an invasion by an invading army, that create a situation in which, in effect, the courts are not open. So the idea has been that if martial law, for example, is declared, that effectively tells the courts to stop operations. The writ of habeas corpus, when it is suspended by the legislature, that's typically because it's not safe or possible for the courts to engage in their normal functioning. That is the sort of invasion that Article 1, Section 9 contemplates, not higher numbers of people crossing the border than perhaps Congress might like. So I don't think there's any question that as a textual matter or as a historical matter that the clause would not be satisfied. But there is this question about whether or not it's something that courts can properly issue a decision on as opposed to leaving it to the interplay between the executive and the legislature.
Are the principles of habeas corpus and due process intertwined?
Yeah, so the writ of habeas corpus is process that someone might be due. So when we think about due process and the fact that the Constitution in both the 5th and 14th Amendments says that people cannot be deprived of their life, liberty, or property without due process of law, is invoking the idea that there is process that one is entitled to, the process that one is due before the government can subject you to one of these sorts of deprivations. And the way that has been understood throughout American history is that the degree of process that is required, the degree of process that you are due, is dependent upon the context. And in particular, it's dependent upon kind of what's at risk for you, what the government's interest is, the thing the government is trying to achieve, and then the extent to which process can safeguard against the government making a mistake. So the government erroneously concluding that someone's not a citizen or not entitled to remain in the country or not properly convicted. So the writ of habeas corpus is part of the process that someone might be due if they are going to be deprived of life, liberty, or property. And so the Supreme Court has indicated thus far is that it believes, even in the context of invoking something like the Alien Enemies Act, that even individuals who are not citizens, even individuals who may have entered the country unlawfully or may have overstayed a visa, they're still entitled to file a writ of habeas corpus as part of the due process that they are entitled to before certain things can be done to them, such as being detained and forcibly removed from the country.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Jonathan Adler. Was there a veiled threat to judges in Stephen Miller's comments? This is Bloomberg. The Trump administration has often challenged the decision-making of federal judges. And White House Deputy Chief of Staff Stephen Miller, in discussing the administration possibly suspending the writ of habeas corpus unilaterally, said the decision depends a lot on whether the courts, quote, do the right thing or not.
The courts aren't just at war with the executive branch. The courts are at war, these radical rogue judges, with the legislative branch as well, too. So all of that will inform the choices the president ultimately makes.
Habeas corpus has only been suspended 4 times in our nation's history. I've been talking to Professor Jonathan Adler of Case Western Reserve Law School. Miller was talking about suspending habeas corpus in the context of undocumented migrants. But could the Trump administration, if it decides to try to suspend habeas corpus, just suspend it for a small segment of the population, or would it apply to the whole population? So all Americans' habeas corpus rights would be suspended.
Well, it depends. I mean, there have been contexts in the past where the writ has been suspended in particular areas, but not everywhere. So Franklin Roosevelt suspended it in Hawaii, for example, pursuant to a delegation of that authority from Congress. So there is historical precedent for confining, certainly geographically, the suspension of the writ. I'm not aware of a suspension of the writ that tried to suspend it for categories of people. And part of the problem there would be is how would you know who you're suspending the writ for if you're not maintaining a process for them to be able to challenge that? This is a similar sort of issue that has been coming up in some of these deportation cases where the administration has maintained, Stephen Miller has said, illegal immigrants aren't entitled to due process. And the fundamental reason why that's wrong is that someone who's alleged to be an illegal immigrant or someone who's alleged to be subject to deportation is entitled to due process, just as someone who's alleged to be a criminal is entitled to due process. To say that someone is an illegal immigrant or subject to deportation is to assume that which process is guaranteed to determine in the first place. And so if the administration, again, with or without Congress, were to try to suspend the writ of habeas corpus just for specified individuals, we would still have this problem of how do we know it's being properly applied to the right people. With geographically based suspensions, that's less of a problem because you're applying that rule or not allowing the filing of the writ in a particular area. Those boundaries are much easier to determine than knowing whether or not the person who's been accused of something is in fact what they've been accused of.
In two recent cases where foreign students were held in detention, they filed habeas corpus petitions and two federal judges have released them pending more proceedings. But in general, is it difficult for defendants to get the relief they want through habeas corpus petitions?
As a general matter, the writ of habeas corpus is often a long shot. I mean, certainly when we look at petitions for habeas corpus filed domestically by individuals who have been convicted of crimes in the United States, these petitions are typically filed to challenge convictions in state courts or to challenge the sentences that state courts have imposed. So quite commonly, individuals who have been sentenced to death file petitions for a writ of habeas corpus. And in that context, unless you can identify a very serious procedural irregularity, those petitions are very difficult to prevail on. So the Supreme Court is usually fairly stingy in granting writs of habeas corpus in those contexts, and that's largely because of a law enacted during the Clinton administration called AEDPA, the Anti-Terrorism and Effective Death Penalty Act, which was designed to curtail the use of habeas petitions to challenge convictions in state court. In these sorts of cases that we're seeing now, I think one of the reasons why we're seeing some of these petitions be successful is because you have individuals who are basically being given no process or virtually no process at all. And so whereas when prisoners are challenging state court convictions, they're challenging convictions where someone has had a trial, where they've had appeals, where something has typically gone up to the highest court within that state. And so there's been a lot of process, and trying to identify particular deficiencies in that process really hard to do with a petition for a writ of habeas corpus. But when you're talking about individuals like, say, this grad student from Tufts who had been detained, who was given virtually no process at all, well, then the argument for a petition is much stronger because while we can debate about how much process someone should get or what the burdens of proof should be, the administration has acted very aggressively in some of these cases and tried to deny people really any effective process at all. And so in that posture, I think it's easier for courts to grant these sorts of petitions.
Did you hear a subtle threat to judges in Miller's comments? He described the judges here as a handful of Marxist judges carrying out a judicial coup, and that the administration's decision whether or not to suspend habeas corpus unilaterally depends a lot on whether the courts do the right thing or not.
Yeah, so I mean, Stephen Miller's not a lawyer, but he is someone that often speaks about legal issues for the administration and often says things that aren't quite right as a legal matter, but I think do echo the message that the administration wants to send, particularly to its base. I think in this sort of context, there is this implicit threat or this very adversarial posture to the courts, a suggestion that if courts don't cooperate or if the courts obstruct the administration's agenda, the administration will look for ways to push back in an extreme way. And this certainly could be one of them. I'm not entirely sure this is an effective strategy for the administration. Certainly I can't imagine lawyers who work in the administration making these sorts of comments publicly, certainly not lawyers that have to themselves appear in court. And it's not clear to me that these sorts of comments are helpful, and I doubt they do much to change the way judges evaluate these sorts of claims. In fact, in some cases, they might even undermine the administration's position insofar as they suggest the administration is not dotting its I's and crossing its T's on legal questions. But I think it's also possible that Stephen Miller, since he's primarily a political advisor, is speaking politically and speaking to the base more than he is detailing what the administration's actual legal position is.
Sort of in the category of he's not a lawyer, but he plays one on TV?
Stephen Miller can be relied upon to offer pugilistic spin on legal questions and on the administration's losses in court, and he presents a very aggressive posture that certainly the administration's lawyers would not take in either their filings or in actual arguments. But I think it's also important to recognize that he's not speaking as a lawyer, often gets the law wrong, and we can often find meaningful differences between the things he says to the television cameras or on Twitter and the things that government attorneys actually are willing to put into legal filings.
Well, we'll see if the administration brings this suspension of habeas corpus up again or it's dropped. Thanks so much for joining me on the show, Jonathan. That's Professor Jonathan Adler of Case Western Reserve Law School. It's day 2 of the trial of Sean Diddy Combs, who's charged with racketeering conspiracy, sex trafficking, and transportation to engage in prostitution. During opening statements, prosecutors portrayed Combs as an abusive kingpin who used violence, threats, drugs, and money to coerce 2 women into drug-fueled, days-long sex parties with prostitutes, while the defense described him as a Harlem-born success story with a tumultuous love life who could get angry or even violent, but that the violent moments didn't amount to the charges the government has accused him of. The prosecution's star witness, Combs' former girlfriend, Cassie Ventura, took the stand today. My guest is former federal prosecutor Robert Mintz, a partner at McCarter English. Bob, tell us about the charges here.
Essentially, what the government has alleged here is that Mr. Combs was involved in sex trafficking 3 women and exercising control over their lives through violence, with financial payments, and by supplying them with drugs. Some of the incidents prosecutors specifically refer to are something called freak-offs, which, according to prosecutors, were these elaborate drug-fueled sex marathons that could last for days. And that was one of the means by which, according to prosecutors, he exercised control over the women who he was sex trafficking for all those years. What's interesting here is that these charges go back 20 years. They're saying that Mr. Combs maintained what's called a criminal enterprise. A RICO, racketeering charge, was included in these charges, in which they say that Mr. Combs used his entourage, basically his various employees, including security guards, personal assistants, household staff, and other supervisors, to enable him with this alleged sex trafficking and to cover it up.
The criminal enterprise part of this, is that a stretch for the prosecution to make this into a criminal enterprise?
Well, that is interesting here because the government has alleged that this criminal enterprise has been conducted over the course of 20 years, from 2004 to 2024, and that part of the acts that were carried out as part of that enterprise included arson, kidnapping, forced labor, bribery, obstruction of justice, and drug violations. But the RICO laws, this racketeering law, which was created in order to battle organized crime, has now more recently been used by federal prosecutors to go after popular figures in the entertainment industry. One example of that was a case in 2021 when there was a federal trial against R&B singer R. Kelly, and Mr. Kelly there was convicted of the sexual exploitation of a child, including bribery, racketeering, and sex trafficking involving 5 victims. So that was a case in which a racketeering enterprise was also alleged against the celebrity, and it was used to successfully prosecute him, and he is now serving a 31-year sentence in federal prison. So we're seeing this more and more, but I think we will see the defense hammer away at that, because their theme here is that what the government is trying to do is to criminalize conduct that was essentially consensual. And they are arguing that the government here has overreached, that they have reached into the private lives of their client, a client who they acknowledge is flawed, whose practices were unorthodox, who had a violent temper, and who they admit committed domestic violence. But in the end, they argue that he was not involved with sex trafficking and should not have been charged with these crimes.
Do you think that's a hard distinction for a jury to make? You know, he's guilty of domestic violence, but...
Well, I think this is a case that really comes down to several things, one of which, the central theme here, is consent versus coercion. And this is where it gets very murky, because the heart of the government's case is the testimony of the women who were allegedly the subject of his violent acts, but who stayed in relationships with him for many years. And so you have that sort of trapped personality, which has now become fairly popular in terms of prosecutions, where women are trapped in these domestic violence situations and they don't leave. And ultimately, the defense is always that they were free to leave and that this relationship, while it may have been unorthodox, was ultimately consensual. The defense here has argued that this case is really about love, jealousy, and infidelity. It was a highly volatile relationship, they acknowledge. They acknowledge that their client went over the top and sometimes acted out violently, which was inappropriate. But again, they're attacking the government for trying to turn what was a heated sexual relationship that was consensual into a racketeering enterprise.
The prosecution has shown the jury a video that a lot of people probably have already seen, where Combs is beating up Cassie Ventura at a Los Angeles hotel. That's going to be a key piece of prosecution evidence, even though it doesn't go to the racketeering or trafficking charges.
Yeah, that will be a central piece of evidence for prosecutors. The defense tried to keep that video evidence out of the case, and the judge ruled that it was admissible. And it does go back to this 2016 incident at a hotel in California where Mr. Combs is allegedly seen beating his then-girlfriend, Cassie Ventura, dragging her by the hair. Ultimately, several years later, she brought a civil suit against him using that video as a key piece of evidence in her civil lawsuit. That case was settled within one day, but prosecutors picked up on the civil lawsuit and ultimately brought these federal criminal charges against him, which mirror to a large extent the allegations in the civil lawsuit filed by Cassie Ventura.
Apparently, he took videos of these so-called freakouts that are very graphic, and the prosecution is going to introduce them. For the jury, how incriminating is just seeing a scene like that?
Well, I think it is difficult for the defense because what they're trying to do is soften his image. They have spent some time already in their opening statements talking about the rags to riches story, how Sean Combs came from a background where he had no money. He's a self-made man. He's become a major figure in the hip-hop industry and a major figure generally in the music industry, responsible for making many people into major music stars. Up until a lot of these allegations came out, he was viewed as somebody who was really very much a role model. But now you've got all of these allegations, and as you say, they also now backed up with this video evidence, which is really difficult for the defense to try to square with the public persona that Sean Combs has so carefully cultivated over many, many years. The video is something that is very difficult for the defense to try to explain away. They're going to suggest that there were things that happened before the video started. Typically, they're going to say things that happened after the video, that it's out of context, that you don't get a real clear picture as to exactly what was going on in the relationship. But those images are the types of things that can be seared into the minds of jurors and difficult for defense lawyers to overcome.
So Cassie Ventura is on the stand, and she's visibly pregnant. How do you do a cross-examination of someone like her if you want to question her motives? For example, why weren't criminal charges brought? Why were just civil charges brought? Why did you stay with him for so long? I mean, how difficult is that kind of cross-examination?
Well, it's the situation that defense lawyers deal with all the time in crimes that involve rape or other sexual misconduct where the victim takes the stand. And the case largely turns, as I think it will in this case, on the credibility of those witnesses. Jurors will be able to look the witnesses in the eye, in this case, Cassie Ventura being the central witness, and gauge her credibility as she tells these stories and as she explains what was going on in her mind as she felt that she was coerced into performing these sex acts and how she was the victim of violence. And defense lawyers have to tread carefully in trying to discredit her, trying to show that she was doing this consensually, that she could have left the relationship, that she had a financial motive, that Mr. Combs was making her career, which he did to some extent. He did get her a lucrative record deal, and she ultimately settled with him in her civil suit for a very large sum of money. I believe it was disclosed as an 8-figure settlement. And they are going to try to suggest that he and the other victims who testify at this trial are really motivated about financial gain, and that they are taking what was a consensual, albeit unorthodox, relationship, one which at one point the defense lawyers actually described as mutually violent, trying to suggest that the alleged victims here were as violent towards Mr. Combs as he was to them, and suggest that this is really a private matter between he and these former girlfriends, and something that does not rise to the level of criminal conduct.
If Sean Combs took the stand, it would be a difficult cross-examination. He did take the stand in his trial more than 20 years ago for firing a gun in a Manhattan nightclub, and he was acquitted. Do you think there is a chance that he might take the stand?
Well, there's always a temptation for defendants to want to tell their side of the story, because they sit there throughout the trial and listen to their accusers, and they obviously have a very different take on what occurred. But it is a very high-risk move on the part of a defense lawyer ever to put their client on the stand. And in this case, we would see prosecutors having an opportunity to essentially retry their entire case through the cross-examination of Sean Combs. And no doubt they would take him through that elevator video from 2016, frame by frame, and pointing out every time he committed an act of violence. And generally speaking, when a defendant tries to take a stand in their own defense, it doesn't end well for the defendant. But anything's possible here, and ultimately it is the decision of the defendant, not the lawyers, as to whether or not he will want to testify on his own behalf. I think what we're seeing so far, though, signals that the defense does not intend to call him, and that they will build their case largely by attacking the credibility of the alleged victims and portraying the government as having overreached here, having tried to tear down a successful businessman in order to try to make a case against a major celebrity by suggesting that his unorthodox lifestyle is actually a racketeering enterprise.
The prosecutor who gave the opening statement is a woman. Mark Agnifilo, well known as the defense attorney, but his associate, Tenny Garagos, did the opening statement. In trials like this, where the victims are women, do you think there's an effort to have women attorneys?
I think in this case, we see two competing issues here. There's a racial issue and there's a gender issue. You have a very successful black entrepreneur, somebody who was successful in the black music industry, who's being attacked by the government here with these serious allegations that, if he is convicted, could likely send him to prison for the rest of his life. You also have a situation in which the accusers are primarily female, and that's something that you often see defense lawyers try to deal with by using female lawyers so they're not seen as attacking the victims here. But we will see, I think, both sides try to deal with these two issues, both gender and race, throughout the trial. And we already did see a motion by the defense to try to strike some of the prosecution's jury decisions, suggesting that they were striking African-American jurors without a valid basis. Ultimately, the judge denied that motion, but we've already seen the issue of race being injected into this trial, and I think we'll see the defense continue to try to do that in subtle ways throughout the course of the trial.
Combs' family is in the courtroom, his 6 adult children, his mother. Does a jury notice that?
Yeah, I think they do. I think jurors notice everything going on in the courtroom. You have to remember that a trial really is very much a scripted event. The prosecutors have their case scripted out. They've already spent hours and hours prepping their witnesses. They know what they're going to ask them. The prosecution's goal is to have the testimony go in exactly as planned. From the defense side, it is a bit more of a crapshoot. They try to attack the vulnerability in the witnesses. You don't know what the witnesses are going to say, and so you have to kind of roll with the punches during the trial. And if you see a witness slip up in a certain way, you may then begin a line of questioning that you hadn't anticipated, but you have to try to pick apart the credibility of that witness. But jurors are watching all of that. They're watching the witnesses. They're watching the reaction of the defendant himself. They're watching the reaction of lawyers on both sides as witnesses testify. And they're also looking around the courtroom and seeing who's there. And there's no question that the president of Sean Combs' family in the courtroom is meant to portray him as somebody who has the support of his family despite these very serious allegations, and to try to convey to jurors that his family supports him in what they believe are unfounded charges against their son, against their father, against their brother.
Thanks so much, Bob. That's former federal prosecutor Robert Mintz, a partner at McCarter English. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.